Our last chapter is chapter 46. The interesting thing about antitrust law is that it should not be studied alone. You should have an economics course alongside this body of law. Many of us are fans of economics. If you've not had a class in economics, though, you in business, you should be required to take one, I think, even if the college doesn't. I think that it's important for us in business to understand the nature of how goods and services move from those that have to those that want it most in the most efficient and fastest means possible. That's the one rule. But it's very complicated because that rule fans out into different directions, and how those directions take place, how they sort of form, varies from industry to market to whatever. So the antitrust law here is simply to curb monopolization. It is, think about this, we use my favorite professor's example, which is soda. If you love cola, if you love Pepsi, if you love Coca-Cola, whatever the brand is, if you love soda, then you want to buy what you want. If indeed, though, there's a local bottler who says, well, I'll buy my competitors out, you have virtually no choice but then that person's choice for the soda that you drink. But you're a lover of soda, so you drive farther away. Your cost increases because of the monopolization in your local market. That is not a right thing. It's not a fair thing. So those that have the ability, like the merchants who are manufacturing, the merchants who are selling, those that have the ability are regulated, as opposed to the consumer, which is forced to drive the 400 miles to get the right soda. So in this area, the federal government, mostly in some state, mostly state federal because of the interstate commerce clause. Much of this area is through how commerce travels across state lines, so it is regulated quite heavily by the federal government. So as you look through this chapter, you'll see the definitions needed. You'll see the understanding. You'll get the idea of this. But remember that the goal here is to avoid monopolization through some form of price fixing. And I just remember there was years ago the federal government dealt with the diaper manufacturers, Huggies and others. They weren't price fixing directly. They didn't call each other up in the night and say, hey, tomorrow's price of diapers, let's all agree. That way we all make the same amount of money and the consumer is out. We can slowly raise our prices and the consumer won't even catch it until we're making tons of money illegally. In other words, without fair competition. We're trying to harm the consumer as a collective body. Well, they didn't do that, but what they did, and they found evidence of it, was they were watching each other's prices, and as one would raise the price, the others would raise. And so by a wink and a nod, not without a direct conversation, the market for manufacturing of diapers, selling of diapers, would readjust itself automatically based upon one price increase. So they all began to shift up and did this for a period of time, clearly under a silent agreement, as you would imagine, control the market. This, the federal government says, was indeed price fixing in violation of the Sherman Act, because you're basically creating a monopoly without even saying so, and they knew what they were doing, so they had to bust that up, and the government responded and held they were in violation of the law, and fines were assessed, and more safeguards were put in place regarding that industry. So do get into this matter. There's a lot of case law. There's a lot of examples where basically people through their companies have tried to take over markets illegally, harming the consumer, harming society. Again, because if you do take economics, you'll realize there's a theory that says a monopolization makes society weaker. We're not able to respond as fast. We don't have choices, which results in less quality over time. There's a lot of economic fallout on this one. Again, I encourage you to take your economics classes seriously. But this is the one where economics will teach antitrust, and antitrust should teach economics, although this book doesn't do that. So there's some definitions to go through in this one in terms of restrictions, restraints, all kinds of ways in which the markets can be manipulated and controlled artificially by those that have the power, those that are capable. The last one is the Clayton Act, which deals with mergers and acquisitions, with price fixing. And again, there's another chapter that we talk about mergers and acquisitions, and hopefully with the two, you can see how the Clayton Act prohibits this kind of harm. I'll use that phrase, chaos, how companies can inject chaos into buying and selling each other, limiting investors, hiding information from investors who need to know, all kinds of problems, and the Clayton Act is the one that is, again, key for that, the busting of that chaos. There is an ability for individuals to sue as a private person under the Sherman or the Clayton Acts. That's on page 28. This one, a lot of private law firms who are plaintiffs' firms get into, and you might have been a member of a claim, a class action, for instance, where you receive notice saying we're going to be suing a particular company for whatever violation. It could be from Netflix to Arco Gas or to whatever, where indeed an individual says, wait a minute, there's some predatory practices, there's some violations of monopolization laws here, the Sherman Act, and I will sue, but I can also collect a group of people if the court will give me an opportunity, and we'll form a class. We'll find out from that company that defrauded me or is forming this monopoly who the parties were that purchased, who the consumers were, who the clients were, and we'll get that information. We'll get a bigger class because obviously it wasn't just me that was harmed by whatever price gouging or some type of vertical restraint or whatever. So this is the one that you might know about because as a consumer you may have been brought into a party class action. As far as the rest of this goes, again, there's more complexity. For instance, how does this work in a global context? That's on page 31. I will leave it there like I've done in the last couple of chapters, which is we're not training you to be attorneys, but we want you to be aware of these problems. You at least need to know that there's thin ice out there on the pond. Don't skate there. Here's the time you pick up the phone, call the attorney if indeed your business is moving into certain directions. Definitely, if you are out there trying to buy up other your competitors, there's going to be a flag here. You need to pick up the phone and dial for your attorney. So that does cover the rest of our book. My approach hopefully will work with doing the PowerPoints and the videos. I promise in good faith that I will try to redo my videos more professionally done manner. Not sure when I can get to it, but I will definitely. I definitely have that on my bucket list of things to do to improve this course. Unfortunately, with the time constraints, the way we were notified, everything had to move online. I don't have that ability, and so I do thank you for bearing with me. It has been an interesting and joyous way to work with you through this online medium. But do, as always, email me. Don't hesitate. And if we need to have a phone conference, we can do that as well. But don't remain in the dark. Always reach out and ask questions. I love questions.